they get cash reserves, they get a bigger bond. They do it all over again the next year, and they get a bigger bond and a bigger bond. And ultimately, you can do exactly what anyone else can do, and that is to grow a large 10, 20, $50 million business and bid work appropriately. But personally, I like the fact that you learn as you go, and you require and attain bonding and credit as your bonding and credit capacity grows based on your knowledge, your skill, your income, and your financial statement. That's why bonding has worked so many years. And the problem with bonding today is that it's supposed to be a zero loss ratio. Is that correct, Mr. McCollum?
Yes, that's written under a theory that there'll be loss.
So it's not a zero loss ratio anymore. And because marginal people get in, it adds difficulty. I'm way over my time, so I'll end there. But thank you for your tolerance.
No, that's fine, Mr. Hanna. We may get a chance to, and I want to begin my questioning on something you raised, which I think it bears further discussion, because no one here, I think, is against competition. You make an excellent point. But I would think, having been through this process myself, both as an owner and as a bidder, one of the difficulties that I always faced was knowing what the rules were in advance. That if I was going to bid on anything, whether it be a contract, a piece of land, a building, I wanted to know if I was in a reverse auction. I want to know how many rounds of bidding there would be. I want to know if there would be multiple best and last offers. Because if I ended up with the rules changing as I got into the process, over the long term, it has a chilling effect. And the next time a bid comes up from that particular or that same organization or a similar organization, I might be much less likely to bid. And I think in the long run, if we allow that environment to prevail when it comes to government contracting, what you'll see is folks like Mrs. Biondo or other organizations simply drop out of the process and decide that if we don't know what the rules are in advance, if I'm going to waste all my time and my money to go through these multiple rounds of bidding, then I'm not going to do it. And I think in the long term, that may have a detrimental effect on the price the taxpayer ultimately pays. Everybody up here, and you and I know each other very well, are interested in seeing the best deal for the taxpayer. But I also think there's a long-term consideration over the system that we create, as opposed to looking at everything as a one-off kind of deal. Let me start with my questions, and then maybe we can come back and throw it open to further discussion. I want to start with, we'll just go in order, Mr. Hare. You had mentioned that there were no rules on subcontracting by small business to large businesses. There were no safe harbors. There were no. It was done on a case-by-case basis. As someone who used to practice law, I can tell you that the world of a case-by-case basis is the world in which the lawyers thrive. We love that kind of thing because it simply drives litigation. Give me some suggestions when we talk about that world of small businesses subcontracting to larger businesses, which we know not only happens but has to happen in certain circumstances. Give us some suggestions for safe harbor rules that you'd like to see.
The two biggest challenges, and you probably are all aware, but how this typically comes up is through the bid protest process. So a competitor will protest a bid of another contractor who is the apparent awardee on the basis that the business relationship between a small prime contractor and one of its subcontractors who happens to be a large business is in violation of SBA's affiliation rules. So a lot of the reason why there is a basis for the protest is because of allegations related to the bonding relationships that are utilized in the project. The prime contractor is required on nearly every federal project. I think Mark would say every federal project, to his Miller Act point, about making sure that you post a bond. And oftentimes the size of the small business set-aside project is so large that the subcontractor may be looked for to provide some assistance in the form of maybe an indemnification or things like that to help the small business subcontractor provide the bond. AGC's view and our view, my view is, that is not something that in and of itself should be improper. You have to look at other things. And I think you could develop a set of rules where, that is something that is specifically permitted. For example, in the mentor protege program, allowing the mentor to help support the bonding program of the protege is specifically allowed and often included. And I think it helps build, a level of relationship for the small business that it can develop with its surety that in some cases is very helpful. But that is a very heavily litigated area right now in this type of work. Another example of a safe harbor that I think would be useful is some kind of clear rule on whether or not different parties can utilize employees of different companies. Just some clarity, so that everybody is playing by the same set of rules, because different competitors will choose to do different things related to how they get labor and executives onto a contractor's staff. And if one contractor is, because of the absence of rules, is doing something and another contractor is not, that often can make the difference as to who gets the job based on competitiveness and a whole range of factors. And I guess my last point, the reason why this has become such an issue is because the Small Business Act has a provision in it that says if you misuse the goals of the small business program, you potentially are subject to False Claims Act liability. And there's no clear guidance on what is and isn't an improper practice relative to the small business rules. And we're starting to see both offices of inspector generals and, in some cases, U.S. attorneys who are taking a look at what we think are legitimate business practices and taking a different view of that and saying that's improper. And now all of a sudden you've got investigations ongoing with a lack of clarity as to what is permitted.